Fourth one, what are the circumstances under which a partnership firm is dissolved? That means what are the situations we can dissolve the partnership firm? Dissolution means discontinuation, termination of the partnership firms. In what are the situation we can close the partnership firm? That is the question. Modes of dissolution of firms. The partnership firm may be dissolved in any one of the following ways. Dissolution of firm, basically two classification. One is dissolution without the order of court, section 42-43 of Indian Partnership Act 1932. Then second classification, dissolution by court. With the order of court we can dissolve the business, that is section 44. Dissolution without the court of order, we have four situations, four circumstances. First one is dissolution by agreement, dissolution by partnership deed, that is section 40. Then second one is compulsory dissolution by the partners, section 41. In that case also no need to go for court. Then third one is on the happenings of certain contingencies, this is section 42. Then fourth one is dissolution by notice given by the any one of the partner, this is section 43. Section 40, dissolution by agreement, there is no subclassification, but second one is compulsory dissolution, section 41, we have further classification, two classification. Compulsory dissolution made due to insolvency of all partners, otherwise in case of illegal business. In that case, that is comes under the compulsory dissolution, compulsory closing of the business. Then third one on the happenings of certain contingencies, section 42 subclassification is some of the contingencies: death of a partner, expiry of the term, completion of work, or adjudication of a partner as insolvent. These are the some contingencies. In all these cases, partnership come to end. Then fourth one is dissolution by notice, that is section 43, no subclassification. So all these are comes under the dissolution without the court order, section 40-43. 40 dissolution by agreement, 41 compulsory dissolution, 42 dissolution on the happenings of certain contingencies, then 43 dissolution by notice. This is one classification. Then second major classification, dissolution by court, section 44. What are the circumstances? Go to court. First one is partner insanity. Then second one is permanent incapacity of partner. Then third one is breach of contract, that means breach of agreement. Then fourth one is misconduct of partner. Then fifth one is transfer of share. Then sixth one is continuous loss. Then seventh one is just and equitable ground. So these are the seven circumstances. These are the seven situations we can go to court for dissolution: partner insanity, partner incapacity, breach of contract, misconduct of one partner, transfer of share, continuous loss, some equitable ground. So all these are the reason to go court for dissolution. We discuss one by one. First one, dissolution without the order of court, section 40-43 of the Indian Partnership Act 1932. A. Dissolution by agreement, this is section 40. A partnership is created and dissolved by an agreement, that means through deed. A firm may be dissolved by an agreement either with the consent of all partners or in accordance with the contract among the partners. So based on the agreement, based on the consent of all partners, they can dissolve the business through proper agreement, through proper contract, through proper deed. This is called a dissolution by agreement. This is comes under the section 40 without the order of court. No need to go for court. This is called a dissolution by agreement. Then B, compulsory dissolution, section 41. A firm is compulsorily dissolved either by the agreement of all the partners or on the insolvency of all the partners except one. if may also be dissolved on the happenings on event which makes the object of the firm unlawful. Example, the passing of Prohibition Act, declaration of war with another country. So these are the situation for compulsory dissolution. All partners are insolvents except one partner. In that case, there is no other way to continue the business. So that dissolution is called a compulsory dissolution. At the same time, our objective becomes unlawful. For example, Prohibition Act, passing of Prohibition Act, government passing the Prohibition Act, at the same time declaration of war with another country. So in that situation, we need to close our business. This is called a compulsory dissolution, section 41.